The other day, one of our viewers said that she was a U.S. citizen who wasn't working. Her spouse was living and working in Mexico. She asked if she had to file an affidavit of support. But since she had no income, did she have to do it or could she just ignore it? I thought for this tip of the week, I would answer that question and help you understand what your income needs to be in order to support or file for your spouse. It's called Form I-864, the Affidavit of Support. My name is Mejer, and I'm an immigrant and an immigration attorney. I came to the U.S. as a child, and I lived without legal status for a long time due to a dishonest attorney who took our money and did absolutely nothing. That's why I became an immigration attorney, so I can help people the way I wish my family had been helped back in the day. Let's handle a viewer's question first. If an application requires a form to be filled with it, you must fill out that form. USCIS isn't going to forget that you didn't submit the form. They aren't going to excuse you from filing all the required forms and doing so correctly. You're setting yourself up for a bad time if you don't submit the required documents. Let's talk about what could happen if your application is rejected initially. In another video, I talked about priority dates. This is the date your application is received and accepted by USCIS. If your application is rejected, you don't get a priority date until you submitted the application correctly. So instead of getting in line, you've made it so all the people who did send in the right form at the same time as you get in line in front of you. I don't know about you, but I really dislike it when people push in line in front of me. I violently dislike it. But this one would be your fault. You're saying, please everyone, step in front of me because I don't want to do it right. Get yourself to the head of the line the quickest way possible by submitting everything that's required when you send in your initial application. If you're not going to invest the time to learn how to fill it out and how to fill it out correctly and how to support the application, then don't do it alone. Hire an attorney. Do not hire a notario because then you'll feel like you're getting the right advice when often you are not. Let's say USCIS accepts your application, but then they notice you didn't submit the form. So they send you an RFE or a NOID. An RFE is okay, it is a request for evidence. You should prefer to not get an RFE or a NOID, but if you get an RFE, it's not the end of the world. It says USCIS wants to approve you, but they need a little bit more information to do so. Go ahead and send your information. I look at an RFE as an opportunity to provide more documentation on every issue necessary in the application. Again, if you deliberately submit an application without the required information so that you get an RFE, you are letting those who may have been behind you get ahead of you in line. Often, many attorneys will prepare the application rather skimpily without a lot of documentation, waiting for an RFE, charge you more to respond to RFE, and only then do what they should have done initially. That's not the approach we take. We recommend providing an overwhelming amount of documentation and evidence at the initial application so that if you get an RFE, it's because it is something that it's usually a narrow issue that the government really needs. And when you provide that response, you normally get approved. At least that's our experience with the approach that we take in cases like yours. So a notice of intent to deny, NOID, that says that the government is planning on denying you and you must prove to them why they shouldn't. Again, your application is put on hold while you gather and submit the evidence, which slows down your processing and your approval. Finally, the worst thing they could do is your case could be denied. This is bad because you have now lost all that time and all the money that you paid. If USCIS denies your case, they don't return the fees you paid. They were used to pay someone to review your case. If you want to submit your application again, you must come up with the fees again and start the process again, or you can appeal it. And there's one other possibility that's even worse. You may be found guilty of fraud if you deliberately don't submit the documentation that you're required to because you want to hide information from USCIS. As I've said in many videos, always be honest. Let's talk about how much money you need to make in order to sponsor someone. The answer to the viewer's question is yes. She has to submit an affidavit of support whenever it's required with the application. In her situation, if she isn't working, she will need a joint sponsor. Now, how much she needs to make or the joint sponsor needs to make? Excellent question. You all probably know by now that the reason you have to make a certain amount of money is that the government does not want to have to support someone with money, food stamps, or other public benefits when they move to the US. The US government wants people who can support themselves, and if they can't support themselves, they want spouses who can support them. The minimum annual income requirement in 2021 to sponsor your spouse for a marriage-based green card is $21,550. That's for a household of two. This assumes you are sponsoring your spouse and you're not in active duty military. You still have the requirement, but you can make less, and that neither of you have any children. As your family size increases, the amount required goes up by $5,600 for each additional person. And if you live in Alaska or Hawaii, which are more expensive to live in, it increases as well. You may be wondering, what source of income can I include? When filing your affidavit of support, you include the total income you list in your most current taxes. This may include wages, salaries, retirement benefits, alimony, child support, dividends, or other income from legal sources. What about if you don't meet the minimum source income requirements? If you don't meet the minimum income required, don't give up. There are other options. You can include income from other adult household members who are willing to agree to support your immigrant spouse or relative. What if you and the other adults in your household don't meet the minimum requirements? You can get a sponsor who lives outside of your household. They are called a joint sponsor. They must also agree to accept full financial responsibility for the immigrant. The joint sponsor must file their own affidavit of support, and they must meet the income requirements on their own. What does that mean? That means that since they live outside your home, they must show they can support their own family as well as the immigrant. The co-sponsor doesn't have to be a family member, but they do need to be a green card holder or US citizen. What about if your fiancé has a really good income in his or her own country? While that is great, unless that income will continue when they come to the US, either through the position or a new one that they have lined up when they entered the US, they cannot count that income in the application. So you don't meet the minimum requirements, like the woman who asked her question, and you can't get any joint sponsor. Now what? One other way of meeting the minimum annual requirements is by counting your assets. You can count your assets and the assets of your spouse, but they must meet certain criteria. If you are counting your foreign spouse's assets, they must be liquid. That means convertible to cash within 1 year. They must be able to move the assets to the US. The total assets must be 5 times the difference between the spouse's income and the federal poverty guidelines found in Form I-864P. So let's say you made $12,000 on, for purpose of conversation, in the question that we were asked, the US citizen spouse said she wasn't working. Well, let's assume she had an income of $12,000 on her last tax return. And the requirement is approximately $21,500. So she was short $9,500. So she must have assets that are 5 times $9,500 or $47,500 in order to be used to make up the difference. You can also include the value of your house or car, but you must deduct monies that are owed on them. So for purpose of conversation, let's assume the house was valued at $100,000 and they had a loan of $30,000 on it. That means she has equity of $70,000. $70,000 is more than the $47,500. So in that case, she would not need a joint sponsor. Since she has income of $12,000, it's less than $21,500. But she has assets that are more than 5 times the difference of $21,500 and $12,000, $9,500. So 9,500 times 5 is 47.5. Her house has equity of 70,000. She does not need a joint sponsor in that example. Does this sound confusing and hard to handle yourself? Don't worry. We take care of all the calculations for you when you hire us to be your immigration attorney. If you need help, call us. If we can't help you, we won't take your money. Thanks for watching. As always, stay healthy and be well.